So in this session, we'll look more specifically at the tort of negligence. Tort of negligence is the most important area of tort law because it's most common in business. What we'll be looking at is the conduct that the law of negligence wants to address, and the principle of the law of negligence as well. We'll look at how you can defend a negligence action and the most common types of negligence suits that you are going to have. We'll lastly look at how that compares to strict liability. Strict liability is you don't have to establish that there was, as we'll see, a duty of care. Now, the reason that we're looking at negligence law is because it's the most common business tort, actually. It covers a very, very wide range of circumstances. And you don't have to show, and this is very important, you don't have to show that the party intended to cause the damage that that you have suffered, in fact. Instead, what you're going to do is assert that the defendant is liable because they failed to act reasonably. Either they were driving too fast, or they gave unprofessional advice, they didn't take the proper care, they were careless or they were negligent, and therefore I suffered a loss and I need to be compensated for that. So it arises where one party, the defendant, has a duty to exercise care in relation to somebody else, the plaintiff. The party, there's the commission of a careless act that causes harm to another, and the person failed to show take reasonable care. Now you've got to show also that the damages were not too remote. Now, to understand the law of negligence, it's also important to show the relationship between negligence and contract. So it used to be the case that if you were buying a bottle of beer, let's say, and you purchased that item, and you gave that beer to a friend. You were both drinking together, you bought 2 beers, you gave one to your friend. The beer that you buy for your friend makes them sick, because the beer is in some way contaminated. Right? Now, it's the case that the person that you have a contract with the beer company because you bought the beer, you have a contract, but your friend does not. He's not in privity of contract, as we might say. Because of that, they don't have the possibility of suing in contract for their losses. So in order to get around this, the courts developed the tort of negligence, in fact. And what essentially it means is that even though the company, the beer company, didn't contract with this individual that got sick, it was reasonably foreseeable that an individual would be consuming that item even though they didn't purchase it themselves. And because they're responsible for that person's losses, they're going to be liable to compensate them. Now, in order to make this case possible, the individual, the plaintiff, the person suing, is going to establish certain elements. They've got to show that they've suffered some damage. Right? They've got to show that that damage has been caused by the conduct of the defendant. You've got to show that the defendant's conduct was negligent, or they breached a certain standard to take care. You've got to be something, it has to be a duty that is recognized by law to avoid this damage. You've got to be showing that the defendant must be the proximate cause, so you must be very closely related to the defendant's action has to be closely related to your particular injury. And lastly, the conduct of the defendant, you were not yourself partially responsible or at fault. That is to say, you were not contributory negligent. So the first part, or step one in proving a duty of care, is to show whether or not the defendant owes the plaintiff a duty of care. Now, in most cases, it's quite obvious, actually. Doctors owe a duty of care to their patients. Professors owe a duty of care to their students, for example. There's a special relationship there. And there's an obligation to avoid the carelessness on the part of the defendant in relation to the plaintiff. It's based on what's referred to as the neighbor principle. So these are all those people that are may reasonably be affected by your conduct. So when you get into your car and you drive it, it's not necessarily there are many other people that you may potentially injure in the course of driving to work, for example. You may injure a pedestrian, you may injure another motorist, for example. Under those circumstances, it would be reasonably foreseeable that the activity that you're engaged in, driving, may cause injury to another if, for example, you're driving too fast. So you've got to show that the harm is something that was reasonably foreseeable and reasonably foreseeable of the defendant's action. If the defendant has been driving 50 kilometers above the speed limit, it is likely that it would be foreseeable on their part that they would cause an accident. And there must be something there must be a close connection between the parties that would make it otherwise unjust or unfair not to impose this duty. So, as I mentioned, normally this is very well established. Bars, for example, owe a duty of care to their patrons who end up going to drive and leave the bar, for example. If there's no precedent as to whether or not the duty of care exists, the courts will look at what was reasonably foreseeable from the plaintiff's position, from the defendant's position rather. Is it the case that the defendant could reasonably expect or reasonably foresee that somebody else might be injured by their conduct? Also, it must be the case that if you're going to establish a fault on the part of another person, there should be policy reasons that may deny that duty of care. So, for example, courts have found while it is foreseeable for a pregnant woman to be harming their unborn child, it's foreseeable if they are smoking, for example, but courts deny a duty of care in this particular instance because even though it's reasonably foreseeable that the unborn child is injured, there are policy reasons against imposing that liability, and that relates to the Constitution, going back to that discussion around constitutional law. The second thing we're going to be interested in establishing is whether or not there's been a breach in the standard of care. Now, the standard of care refers to that standard which is imposed by the law that causes the individual to act in a certain way. It doesn't necessarily have to be in law. It could be by a professional body, such as the Accounting Association or the Law Society, which establishes what is reasonable conduct in the particular circumstance. So the standard of care relates to what would be reasonably expected by a person in our society. Now, if the person happens to be a professional person, they're held to a higher standard than the average person or a person with that particular skill or expertise. In the case of a person that's rescuing another individual, there may be a lower standard of care being imposed. Part of the reason for this is that the law wants individuals to engage, to assist others in our society. So, for example, let's say you are driving your car, but you don't have a license. You're going to be judged by the standard not of an inexperienced 12-year-old driver, but by the standard of somebody who's passed their driving test. Driving exam, in fact, establishes the standard of care. That standard will determine how you should your conduct on the road. If you have fallen below that standard, then you are said to have breached that standard of care. You also have to show that the defendant's action has caused your losses, the plaintiff's damage. There you've got to show that there is a relationship that exists between the defendant and the plaintiff, and this is important, that the plaintiff has to show that their harm would not have occurred, and we say but for, were it not for the defendant's negligent act or omission. If there are no damages that's experienced by the plaintiff, then the lawsuit's going to fail because damages must exist. The last thing you have to establish to claim negligence is the fact that whether or not the damage is too remote. Now, it's the case that if there must be a sufficient connection between the defendant's action and the plaintiff's losses. So in a case that we are going to look at in more detail, Mustafa and Culligan, there is an individual who is supplied with water from the Culligan Water Company, and it has a fly in it. That fly causes psychological distress on the part of the person consuming it for himself and his family, and he sues not in contract for the amount of the water or the price of the water bottle, but for his psychological distress. Now, it's established that he has suffered these losses, but what the courts say that even though there was this standard of care, there was this duty of care, that duty was breached when the fly was found in the water bottle, and it's caused his suffering. The damage is too remote in the sense that it would not be possible for the water company to anticipate this particular reaction from this particular individual, and therefore the liability is not imposed. Important aspect of negligence also is referred to as the thin skull rule. Now, this means that if you are hitting a pedestrian when you're driving on your route home, for example, if the defendant happens to be a hemophiliac or suffers some bone condition such as osteoporosis, it's the case that you are not just liable for the victim's losses if it were an average healthy individual, but an individual with that particular condition. So that is to say, you are going to be liable for the full extent of the plaintiff's injury, even if they had a pre-existing condition that makes their losses far more than would otherwise be the case. Pure economic loss is not typically dealt with in tort law. It's normally dealt with in contract law usually, and this is just simply financial losses. Normally that is going to be dealt with in contract rather than tort, but it does occur in certain circumstances. Defenses to to negligence are contributory negligence, where even though the defendant has been unreasonable and he's caused your injury, you yourself are also partially to blame for your own losses, and therefore the court will reduce your damage award by your percentage of fault. If you have engaged in a high-risk activity and you've assumed the risk of engaging in that activity, the rule of voluntary assumption of risk is triggered, and that means that there will be no liability since the plaintiff has themselves accepted the risks that are inherent with that activity. So let's say, for example, you decide to go skydiving. Skydiving is an inherently risky activity. You will sign a waiver or an exemption of liability clause that will exclude or exempt the skydiver operator from being liable for your injury if you are injured in the course of that activity. So the defendant, the skydiving operator, will have to show that the plaintiff has voluntarily assumed the legal and physical risks associated with that activity. In the case of negligent misstatement, when this occurs in professional context where you have made an incorrect statement or careless statement that the person has relied on, this often is occurring in the professional context where an individual gives wrong advice. Also occurring, it's important to round off this discussion, is product liability. So where the liability arises from the defective design or manufacture or sale of that particular product. It would also be covered in contract if you have a contract with that individual, but it also can be extended, broadened, and that liability you as a manufacturer can be exposed to far more liability in negligence as well. So these are situations where contract overlaps with negligence. So you have to appreciate that negligence is an inherently sort of organic or flexible growing area of law, which changes in relation to standards of conduct at various points in history. There are these 4 steps in establishing a claim in negligence, and we've got to establish those to prove that an action will succeed. There are defenses to negligence, known as contributory negligence or voluntary assumption of risk, and there are areas of business activity, such as product liability, where the law of negligence and contract will overlap. So for next time, what I'd like you to do is read the case of Mustafa and Culligan, which is provided in your content folder for this week, and try the problem question which I provided for you in this week's session, and we'll take that up in the next class. Thanks very much.